So cool. Well, look, it's a pleasure to be here, and looking forward to talking a little bit about estate trustee during litigation, but also limited grants. And I guess what makes me really bring top of mind is I don't know how you're seeing the practices, but I've certainly outside of Toronto and then within Toronto, the real estate bar is seeing a shift, and that is, of course, people are starting to walk on deals because of the economic situation not being as positive as it used to be. And as a consequence of that, where the concept of limited grants has been an opportunity for us to deal with that urgent situation where, for example, if you need probate to close the deal, or if you want to pursue litigation and you want to get probate to do so. So we'll talk about the limited grants as well, but let's start with the estate trustee during litigation. And I guess the starting point always is that, what is the estate trustee during litigation's role? Why do we have it? It used to be called a pendente lite. So they got rid of the Latin phraseology of it, but it is what it is, exactly as described. It's putting an estate trustee during litigation into the mix, and the broad sense of the word. It used to be that the estate trustee during litigation was only appointed in rare situations. And that was probably within the last 5 years. The law has changed that a little bit. But the concept is that the court has the ability to put in a person or an entity to operate the administration of the estate during a period of time where matters are being litigated. And that used to be, of course, in the context of a will challenge. I still am not crazy about the expanded version of what this has brought out, but I think we should know, as practicing on the solicitor side, what cannot happen. The genesis of this, of course, comes from Section 28 of the Estates Act. And if you look at the language, I always read the language pretty clear. It's pending an action touching the validity of a will. And historically, that, of course, was the broad parameters of which we thought you would appoint a state trustee during litigation in, and that it would be typically only done in a situation of a will challenge. And that's opposed to Section 47, I think, of the Trustee Act, which deals with circumstances where you want to remove a trustee. So the validity of a will, pending a proceeding relating to the validity of a will, is one category of where a new trustee could get appointed during litigation in this case. And Section 47 of the Trustee Act is where a trustee who is appointed under a will or is acting as a trustee could be removed. And of course, there was a very big difference between the two that took the courts from the 1870s, a Letterstedt decision, to say that if you're going to remove a trustee, it's a very high bar to being removed, and as opposed to an estate trustee during litigation, which could be appointed in the right circumstances for a much lower bar, evidentiary bar, and factual bar to hit. And that was really, I think, the policy behind that is that we wanted to allow matters to proceed, i.e. the administrative matters to proceed without disruption in a context of a will challenge, because of course the will that's being challenged, the appointment of that trustee is also being challenged in the context of that. So the world of estate trustee during litigation and the world of trustee removal seem to be separate and apart. And it seemed to me until the Rubin decision seemed to be that you had to really have a will challenge to appoint an estate trustee during litigation. That has since changed with the Rubin decision. We're going to talk about that in a second. But anyway, I just wanted to set the stage of the delineation, because the historic delineations inform us as to when the court will put in this interim estate trustee. And that's really what they probably should be calling them now in that sense, because it's being used as an interim appointment. So Jordy, those are kind of my opening thoughts on it. Do you have some opening considerations before we go through this?
Yeah, just that I mean, to reiterate what you said, I mean, the idea was where the validity of a will was challenged and we didn't know who the executor was ultimately going to be, because either this will was valid or it wasn't valid, and therefore this will was valid, or there was an intestacy. We needed somebody to administer the estate. While that fight was, while we were determining who was the valid executor. That was the issue. That was the issue, and that's the creation of this Section 28. And I agree with you that I think courts, I think the name made it a little bit, by using the idea of an estate trustee during litigation, it was almost like any litigation. Let's think about a neutral party, which wasn't the concept. The concept was, that you only needed it when you didn't know who the proper executor was, because we didn't know what will was valid. And so that's changed, I think. Not sure it makes a lot of sense, but maybe it does. You're on mute.
Thanks, Jordy. Sorry. I think it makes no sense, but that's so what? I mean, I don't have the sash across my
Right.
my chest. I think what's important from my perspective is that if I'm sitting across the table taking will instructions from my client, and I'm in a tumultuous situation with the client in the sense that I'm not, but the client's in a highly charged situation. It used to be you had some confidence that not just a will, that only if the will itself was challenged would the appointment of a trustee removal actually be a realistic remedy available to the complaining parties. That's gone now. In the Rubin case, Justice Myers made the decision that appointed an estate trustee during litigation outside of the context of a will challenge. And as a consequence of that, since then, the courts have broadly been appointing estate trustees during litigation in all sorts of will related matters. And I think with really very little regard to what I think is Section 29, but more importantly, the sanctity of the appointment of the estate trustee at the outset. And I see
so
you've highlighted it.
The Rubin case was not a will challenge. It was a trustee, as you say, it was a trustee removal case, and they were fighting with one another. And so the court said, while you guys are fighting over whether we should remove one of you or not, we're not going to let you guys manage the estate. We need somebody else to do it. And they called it, they relied on Justice Myers relied on Section 28 to do that. Rather than where the very document that gives authority was in dispute. That wasn't the case here. It was more just a warring faction of trustees against one another that sort of led to that.
Yeah, and they also expanded it. He said, if I'm wrong, I'll use Rule 1.03, which is the broad powers of the court to deal with the administration. And again, I don't, Justice Myers had his own reasons. It was a very sort of a spicy case factually, and there may have been lots going on that we'll never know because we weren't in the room. But to have to sort of stretch Section 28 and then fall back on Rule 1 again just reminds me as to how far the courts are going to go to readjust estate planning that we're doing for our clients. And I don't like to underestimate the fact that really it's a moving target. We're becoming more like a family law bar, because it's important for me to relay that to the client, to say, you know what, even if there's an interpretation, if there's a trustee removal, or there's a dependence relief case, I can tell you all three of those scenarios now, I am facing courts that are saying, I'm facing cases that are considering the appointment of a state trustee during litigation. And it's almost always based on the fact that they're saying, well, the existing trustee who's appointed is in bias or in conflict. Well, as we both know, Jordy, almost every time you appoint a trustee, there is a bias and a conflict. And
right. I mean, the rule I thought was, if I'm the testator, I get to pick the person who's in charge of my estate. And if I appoint two people I appoint a person who's in a conflict of interest, assuming I knew about that conflict of interest when I chose to appoint them, then yeah, that's my pick. And that's what the case law said historically. And you know what drives me crazy? Not so much this fighting between trustees and look, we need a neutral party. It's when I get a dependent support claim by a dependent saying, yeah, I'm owed money from the testator, and that the executor, who's a beneficiary, is saying, no, you're not. And that the dependent says, oh, we need a neutral party to act on behalf of the estate. And my theory is, since when does the plaintiff get to pick the defendant? I mean, that would be great. I would always love to, if I sued somebody, I get to pick a neutral party who has nothing to say, nothing to do with the outcome. I mean, to me, that is the craziest argument. And I think is it successful, Ian?
Well,
that the dependent gets to pick who's going to defend for the estate?
Well, it is, in the sense that most of these cases, A, because of COVID, you can't even get a short-term hearing, an interim hearing on these things. And B, none of them get to the trial level at this point anyway. And so, yes, it's a very successful tool, and you're in a mediation trying to defend the claim and defend your appointment, which is a leverage point that the person seeking support never had before. And it's all because of the consequence of this decision that, again, I think it's made sense in the moment. This was a warring trustees, and they were very concerned about some, on the administration standpoint. What things like this happen, and happen with Milne and happen with other decisions. There's a ripple effect. And the sanctity of the appointment, for which we've lived with for 150 years, is now undermined in every single case. And it's going to ripple effect into guardianships as well, and powers of attorney fights, because there have been rare occasion interim guardians appointed. But again, there is no provision in the legislation for an interim appointment of a guardian under the Substitute Decisions Act yet. That's going to be the same thing. People are going to be looking for that kind of outlet pass. But without
it was probably
complaining,
it was the right decision. It was the wrong section. It shouldn't have been an estate trustee during litigation that's appointed. It should have been a temporary removal of the executors, and so maybe it's just nomenclature, but what it did do was say, oh, then Section 28 doesn't just apply to a will challenge; it can apply to anything. And so, probably it was the right decision, but unfortunately, leading to other issues. What about the classic will challenge case and an estate trustee during litigation? So I'm challenging your will, you're propounding the will. What are the chances I'm going to get get the executor in essence removed, or get an estate trustee during litigation appointed while we're fighting about which will is valid? What would you say about that?
So back in the 50s, a case called Rebazos that said, look, if there's a will challenge fight, I'm, as a judge at an interim point in time, I am not going to get involved. I am not going to step into this one. Let's get someone neutral in there now, so that the estate is being administered in a fair and judicious way. And that Rebazos decision is not only the right decision at the time in the context of that case, but still resonates as the most logical approach in 90% of the cases. I'll talk about it in a minute where the exception is, because as lawyers, we always can find an exception. But on balance, Rebazos has led the law on the determination by the court that if there's a classic will challenge, the court is not going to step in the middle of that one. They are going to typically pick a neutral party, and who that neutral party is can depend on the circumstances, but is often either a trust company or an accountant or a lawyer. Trust companies are typically favored because the bonding issues and so on are eliminated, and it's the safest route to go, as judges like to try to go to the safest route. But that's what's happened and continues to happen. In fact, I just argued a case on this very point recently in front of Justice Dietrich, seeing if I could fall into the exception, which I'll talk about in a second. But the rule is absolutely as set out in Rebazos.
So we have a situation where you got conflicting wills. That assumes basically that the executors under the two different wills, and we're not sure which one is valid, are different. Some of the cases where there was an exception to Bazos, where the court said, look, we don't need a different an estate trustee during litigation, is where regardless of which will is valid, it's going to be the same person as the executor, right? And so those cases, if you're in that situation, certainly there's case law in that supports the argument that, look, we've got a neutral party. They're going to end up being the executor one way or the other. And so let's just keep them in place, right?
Yeah, and that's right. And there's also the exceptions that kind of drew out of the fact that if you're in a complex administration and the executors are performing and have been performing for some period of time in, if you're acting on an estate that's got multiple buildings or something like that, and the executors have had both feet in the ground administering the estate, there's also that exception that exists in the cases as well, where the courts sort of say, look, it's not perfect, but they are the ones closest to the ground. It's the most efficient way of maintaining this. And I don't see any real risk to the warring parties to preserve that appointment.
So this case that I just pulled up, and actually I didn't realize when I pulled it up, it was your case,
Yes.
and really recent, right? This was, you just argued in February.
Yep.
I didn't check the end. Did you win or lose?
I did not. Well, I don't like to use the word lose. I didn't persuade the judge that I was right.
Okay. Well, we can appeal. So this is your classic, right? This was a classic kind of will challenge case. And so I'm sorry to have done that. I should have probably found that out before, but it shows everybody that this is live and it's not, we haven't rehearsed this, right? Because I would never have asked you that if I had known the answer.
I could care less. I lost it. I lost it miserably.
So this case is Coughlin, Cabrera and Coughlin, and just a recent example of, and the court did an evaluation of, cited the right cases and said there are examples of each case where we're going to appoint a neutral party and where we're not going to appoint a neutral party. And so this is just, if you're looking at this issue, it's probably a recent, obviously a very recent, but also one that sort of highlights not just a one-liner where we used to see that. In fact, the first motion I ever won, real motion I ever won, was an ETDL motion in front of Justice Haley. And I got very excited. And I think Justice Haley said to me, yeah, oh, that, yes, it's okay, Mr. Ayton, like, calm down a little bit. Because I had this feeling like I was going to win, and it's just calm down a little bit. So anyway, I remember that important.
Yeah, no, and that's your reaction is very important, because in the long play of litigation, it's so important, and early decisions can drive the motivations on the client side. They can give the lawyers views of the likelihood of success of the big case too. But it also, what it can do is it can be a bit of the canary in the coal mine on your case. And I noticed certainly with Coughlin was a great example. It's just an excellently written decision. It goes through all of the parameters. The judge did struggle. Sometimes there's close calls. And of course, I did lose that one, but I think that what the decision demonstrates is that there are opportunities to consider a close call on these. But on balance, generally speaking, it is a situation where you're going to typically lose the fight and you're going to incur costs, which are going to be probably unrecoverable. And so I'm very cautious about going too hard on that part of the lawsuit. I don't want an early loss in the case if I can help it.
That's, that was my point in, I once wrote an article and became part of a chapter in a book about estate trustees during litigation. And the point I made was that is likely the only argument you're going to ever have before a judge. And think about how powerful that is, a win there. What you're saying to the person who's propounding the will, who thinks, what are you talking about? My will's valid. I'm the executor. You get them removed in front of in favor of a neutral party. All of a sudden, it's like, hold on a second. This is actually a real issue now. I'm not in charge. And they stuck somebody neutral in, and maybe the will's not valid. I mean, it is a huge psychological and tactical issue, at probably the only one that you're really going to fight about, because you're 99% of these cases will settle at some point. So that's why this argument about an estate trustee during litigation is really worth much more than it might appear. Do you agree? I guess you agree with that point.
Oh no, I totally agree, and I think you just said it the best. Like it will be much more of an impact than you think it will be, and so 99% of the time you just don't want to have that fight for the reasons we've discussed. And I do think there is the judges talk, and judges also read the file, and they read the decisions that are in the file. And if there have been prior decisions when you're going to trial, you better have had a bloody good reason to take a hard position on ETDL, because sometimes it's why doth protest so much, and what is it? Why were they so upset by it? And it can be an emotionally driven thing, and it can have a real ripple effect. So okay, so Jordy, sorry, anything else on ETDL? I just wanted to spend 5 minutes on the.
Yep, please.
All right, so it's limited grants. I just think this is such an important thing to keep top of mind in my practice now, and I've got 2 on the go right now. This falling market is people are walking on deals. You're sitting there, you're looking at an opportunity to close a deal, and you can't get probate because of the backlog with COVID. This is an opportunity to go to the court and get there's a whole bunch of Latin phraseology that no one uses anymore, but at the end of the day, we call it's now properly called a limited grant of probate. So you go to the court for the sole purpose under section 29 sub 3 of the States Act.
I'm going to pull that up.
Sure. To go to the court as a stopgap to obtain a probate, in order to issue probate for the limited purpose of one specific task. And so, for example, you can rush to court and say, I need to have an order that says, give me probate for the sole purpose of closing this house deal, or give me probate for the sole purpose of paying this CRA debt, something like that. But the real estate deals is something that is top of mind, obviously, in terms of situations where you've got a log jam in getting the formal appointment, and there's a variety of scenarios where that can occur.
So that's, I think, right. I've got this subsection 3, which is quite broad. It's really, or other special circumstances, aside from, insolvency or nobody applying or whatever. So do you find that you can get these relatively quickly? I mean, what does this require? Is there a form, or do you have to go before a judge? How do you get one of these?
Sure. It's before a judge. It's relatively simple to do. You just put an affidavit together in your notice of application, citing section 29.3, saying, I need this limited appointment, and here's why. Here are my grounds for relief, and that is that there's got to be a specific element of it. It's also an important tool if you've got log jam with 2 trustees who won't get out of a log jam. You can pile on a few other pieces of relief, like the orders for assistance. But this is another easy example of a situation where if you've got a logjam with a trustee and something has to be done urgently. The real estate deal is top of mind, but there's lots of scenarios. It's just one of these things to have in your tool chest to make available. It's not a burdensome application. The courts have lots of statutory authority to do this, so they typically will make the appointment. You restrict the actual you actually put in the order the restricted activity that you're seeking. And so I often will put in for the real estate deal, I'll put in for the sole purpose of completing real estate deal on this house, and identify it to make sure that the court hasn't given me more powers or less powers than I'm entitled to. As long as you're specific about the actual power, my experience is these orders are relatively straightforward and easy to get.
Yeah, and how, and is it enough? And have you done this where literally you're sitting waiting for probate and it's taking forever? Have you ever, can you get this faster than trying to get contact at the courts? Or
Yeah, so essentially an urgent application you can bring, get on the urgent list or the faster list. You can typically persuade the court to give you the time as long as you can show the urgency. The difficulty is if you say, I want a probate issued urgently, that's a broader expectation. And the court's going to want to say, okay, well, wait a minute, why isn't the probate being issued? Well, for the purposes of this, I'm going to have to scrutinize the probate document. That means the registrar's got to go through the full process of scrutinizing the registration, the application.
Mhm.
All of that gets eliminated by just saying to the judge, look, I just want this job. I
Right.
will do that. Once I get done, I'll get out of the way and nobody's going to give me more authority than that.
Great, great. Ian, we've got a couple of questions. You think we have a couple minutes?
Yep.
All right.
Yep.
So what about planning for this possibility that there's going to be a will challenge and an estate trustee during litigation appointed? Some questions about can you put in provisions in your will that, if there is an issue, I want it to go to mediation. And if there is an issue, and if somebody appoints an estate trustee during litigation, I want it to be this person. Have you ever seen that?
I haven't. Obviously, you can put anything you want in the will like that. It's precatory. It's only a wish. It's not going to be binding per se. It might telegraph the issue, and the judge might get some comfort for it, that you put some thought to it. But I just don't see it being used as a tool very often. And I also think it can be a bit dangerous because you're kind of showing your cards in the will itself. You're almost teasing out the expectation that there's going to be a will challenge. I think you're probably better off just putting a no contest clause in. That whether its effectiveness or not is another day. We'll have no doubt a seminar on the impact of no contest clauses, but I'm not sure it's such a great idea to start articulating those kinds of that kind of language.
And I mean, are any of these useful if you've got an executor, who's just not doing their job? I mean, what would you do if you just had an executor who's just not, it's not a will challenge. It's, you got an executor and I guess it's a removal application, right? Is that?
Yeah. And the limited grant has to be carefully used too, because it's sort of crying wolf. Under the rules, the orders for assistance give us all sorts of remedies. And it's not right to, in my view, to go to the court and sort of pick on this particular remedy as a sole route to go. You can look to the orders for assistance where the court can step in and force an individual to accept or refuse the grant, or you can get directions on to take administration steps. And you can go under Section 47 of the Trustee Act to remove it. So I tend to, if I'm getting a situation where I want a limited grant and I need to pile on all those extra issues, I typically won't do it. I will use the limited grant sparingly and use it for where there's an identified moment in time and a purpose for it.
Great. Well, Ian, maybe we'll talk. I know on our list of topics is removal applications and getting what do you do if you've got an executor, whether it's litigation or not, and who's not doing their job. And so we'll raise that, and we can talk about orders for assistance. But thank you, everybody. We're not a couple of things. We are not having a webinar next week, which is the long weekend. So everybody's got a week off, so that's good. And I was in touch with somebody in the rules committee about some errors in the forms that are being released on July the 1st, and they've cleaned up a couple of things. So nothing major. It was just the helpful hints where it said put in the applicant's name. It now says correctly put in the deponent's name and things like that. Nothing really changing the form, but just to clarify those things, because I did mention them last week. So thanks, everybody, and I hope you have a great week and holiday and Canada Day, and we'll see you in early July. Thanks.